Good morning, everybody, or good day, wherever it is you are in the world. My name is Paul Diller. I'm a professor at Willamette University College of Law in Salem, Oregon, and I'm pleased to moderate this panel entitled States of Emergency, Executive Orders and Separation of Powers During the COVID-19 Pandemic, which has been selected as a hot topic for this conference. As we all know, COVID-19 has upended life in the United States and around the world in myriad ways. In addition to the countless deaths and illnesses it has caused, it has also led to an unprecedented use of emergency authority by executive officials at the state level. This has mostly been exercised by governors, but there have been other executive officials who have exercised emergency authority as well, like secretaries or directors of state public health agencies. And using this authority, these officials have promulgated orders that changed American life in ways that previously would have been unheard of, closing schools for months, closing businesses deemed non-essential, limiting public gatherings, and of course, closing or limiting meetings at houses of worship. Yesterday had an excellent Hot Topics panel devoted to the First Amendment issues raised in the religion context. And I was pleased to hear there somebody mentioned at some point, well, you really got to get into the underlying emergency authority that governors are relying on when they close churches or limit attendance. And that's what this panel will aim to do. So to unpack the various state law issues, as well as some constitutional issues at the state and federal level that have arisen, we have four superb panelists whom I will briefly introduce in their order of appearance. First, we have Lindsay Wiley, who is a professor and the director of the Health Law and Policy Program at the Washington College of Law at American University in Washington, D.C. Professor Wiley will provide an overview of the primary legal issues regarding state emergency rule, including separation of powers and non-delegation concerns. Next, we have Mitch Krusto, who is the Henry F. Bonora Jr. Distinguished Professor of Law at Loyola University, New Orleans College of Law. Professor Krusto will focus in particular on the right to travel and issues raised by stay-at-home orders and state quarantines or limitations on entry from out of state. Next, after Professor Krusto, we have Daniel Rodriguez, who is the Harold Washington Professor of Law and former Dean at Northwestern University Pritzker School of Law, also a former president of the AALS. And Professor Rodriguez will speak about judicial intervention and mandatory orders, as well as looking forward to private non-governmental initiatives like immunity passports and vaccine requirements. And finally, last but not least, joining us all the way from the other side of the world in New Zealand, where it's even earlier than it is here on the West Coast, but it is tomorrow, is Miriam Seifter, who is Associate Professor of Law and Rowe Faculty Fellow in Regulatory Law at the University of Wisconsin Law School. And Professor Seifter will speak on political polarization and how the counter-majoritarian nature of some state legislatures complicates arguments about democratizing emergency responses. I'll just say a brief word about the format before we get going. Each panelist will speak for about 5 minutes to start. After that, we'll transition to more of a Q&A led by me, and I'm also going to keep a close eye on your questions in the chat. So keep them coming. If you have a question for a particular panelist, let me make that clear for me by writing, Q for so-and-so, just if you really want to get my attention. The chats I saw yesterday were very active. So with no further ado, let me hand it over to Lindsay.
Thank you, Paul. I appreciate being invited to join this session and being able to address all of you this morning. I'm Lindsay Wiley, Professor of Law and Director of the Health Law and Policy Program at American University. And I began my career in public health law at a time when enormous resources and attention and interest were being invested in emergency preparedness and specifically in public health law modernization in the aftermath of the 2001 jetliner and anthrax attacks. And that really shaped my interest in the field. It's the reason there were jobs for me coming out of law school or even during law school. And I've worked on those issues for my entire career. In 2020, it's been hard to put into words how difficult it is to see how little government officials and institutional leaders have used the plans and insights generated by those massive investments over the last 20 years. We've failed to protect the public's health. We've also failed to protect the public from the economic devastation that a poorly managed public health emergency causes. We failed to prevent devastating double impacts of the pandemic on people racialized as Black, Indigenous, and Latinx. We failed to protect disempowered essential workers and the people they live with and the communities in which they live and the broader communities that they serve. We've called on individuals to change their behavior. This is in many ways what Sam Bagenstos and I have called a personal responsibility pandemic response. But we've failed to empower and support individuals so that they have the resources they need to protect themselves, to protect their families and their communities. So public health law modernization and public health emergency preparedness brought about this renaissance in my field in the aftermath of 2001. They were also shaped by the influence of warnings about avian flu pandemic, a near miss for the US at least of the 2003 SARS outbreaks, and also the failed response to disasters like Hurricane Katrina in 2005. But these modernization efforts, which resulted in fairly sweeping reforms to state public health emergency statutes, they focused almost exclusively on individually targeted strategies, like compulsory screening with available tests, supported isolation for individuals who test positive, impeccable contact tracing of their contacts, epidemiological investigations to determine where and how the virus is spreading, and quarantine that's individually targeted or at most targeted on a specific facility where an outbreak is occurring. But these strategies assumed that an infection would either be readily detectable through telltale symptoms or that testing would be massively ramped up immediately. There was just widespread understanding, as there was in early 2020, that testing, mass testing, readily available testing was critical. When SARS 2003 outbreaks were much too serious, much too widespread for individually targeted measures to handle in hard-hit places outside the US, international and federal preparedness plans incorporated the concept of social distancing among the general population. But it's really important to see how those early conceptions of social distancing as something that governments and institutions would do to support the ability for people to stay home voluntarily and to shrink their in-person social networks, largely without any restrictions on individual movement. Those plans have really been worked into something, even just the term social distancing has come to be used to describe something individuals are responsible for doing while being required to report for duty in gathering places. Whereas originally the idea was to have institutional responsibility, government responsibility to close those gathering places and provide the supports needed to increase social distance in the general population. So these plans really focus more on voluntary institutional policies, government supports, than on restrictions on individuals. There were intended to be business closures, but experts assumed that really intense restrictions on the general public would be impossible to maintain for more than a few weeks at a time. The 2004 federal plan referred to the idea of snow days, that in an extreme situation, businesses could be closed for a week, 2 weeks to blunt peak impacts, but certainly not for the months to years that could be required to achieve herd immunity through either acquired infection or vaccination. So these two efforts, though, public health law modernization in state legislatures and planning to support social distancing, did not merge. And I think that was a critical failure pre-2020. Modernization reformers were focused on supporting a modern public health response based on widespread access to testing, treatments, and eventually vaccinations. But post-SARS plans were kind of a throwback. They were built on the kinds of interventions that hadn't been seen in the US, at least, since the 1918 flu pandemic and to a much lesser extent, mid-century polio outbreaks. The failure of these post-2001 emergency health powers reform efforts to incorporate the lessons of the 2003 SARS outbreaks meant that key legal questions for which pre-pandemic judicial precedents provided very few answers were not addressed in state and federal statutes. And so in the 2016 edition of our public health law text, Larry Gostin and I joined other experts in pointing out that that massive government and institutional supports, accommodations and legal protections for employment and renters would need to be implemented to ensure that restrictions would be effective, that they would be sustainable, and that they would be equitable. We also argued that long-term social distancing would raise legal questions about who has authority to order restrictions, by what criteria, and for how long, and what would the role be of the courts, of the legislatures, as executive officials were making these difficult choices. As the courts have grappled with these questions in 2020, the disputes have predictably centered around the two fundamental tensions in public health law, policy, and ethics. First, the balance between the common good and individual rights and liberties. And second, and this is really going to be more the focus of our discussion today, the balance between deliberative democracy with its checks and balances and a swiftly implemented, nimbly tweaked, expertise-driven executive response. So today our discussion is going to delve into these questions in some detail, with a particular emphasis on the structural tensions over the roles of executive branch officials, the legislatures, and the courts in pandemic response. Federalism, preemption, statutory authority, and separation of powers are all critical components of public health law as opposed to healthcare law, where they play a different role. And all of these issues have been raised by various aspects of the pandemic response. On the individual rights side, the big issue has been the immense popularity of the Fifth Circuit's interpretation of the Supreme Court's 1905 decision in Jacobson to require a suspension standard of review rather than ordinary balancing, in which the exigencies and limits on scientific understanding that come with an emergency are taken into account as part of the constitutional and publicly facing as well process of justifying government intrusion. On the structural side, elected officials have argued over who holds the reins on social distancing and face covering orders, whether time limits are renewable, whether orders fall within these broadly defined grants of statutory authority to respond to emergencies or control the spread of communicable disease, and if so, whether these broad delegations provide sufficient guardrails to avoid running afoul of separation of powers. These disputes have occurred against a backdrop of the federal administration's utter failure and the Senate majority's total failure to provide the critical supply chain coordination and financial support necessary to implement a modern public health response built on widespread access to testing, contact tracing, epi investigation, and supported isolation. State and local governments have been left largely on their own to fight this pandemic like it's 1918, with saloon closures, now bar closures, and face masks made, homemade face masks rather than high quality PPE. And those state and local governments have largely shifted the burden onto individuals. New vaccines have been authorized. Each day, more people are receiving their first doses. But with the doses we expect to be available, we're unlikely to be able to vaccinate a majority of the US population until mid-summer at the soonest. For the coming stages of this pandemic and the next one, we're on the cusp of what I anticipate will be a decade of reforms to public health law and public health emergency powers. I expect these reforms to happen in the regulatory and legislative side at the federal, state, and local level. I've written about the principles that I think should guide these reforms. I'll just briefly summarize them here. Statutes should mandate transparency to the public about the scientific understanding on which they're based and the criteria by which they'll be modified. Emergency executive authority should be time limited but renewable. The default should not be inaction. Statutes should authorize a graded range of alternatives and not prohibit actions that target specific types of facilities or businesses to facilitate a scaled and sustainable response. Statutory standards should promote neutral orders that are defined in terms of risk and scientific understanding and that don't discriminate on the basis of religion. Legislatures should mandate provision of supports, legal protections, and accommodations for safer alternatives to restricted activities within available means, using a kind of progressive realization principle borrowed from international human rights documents. And criminal enforcement against individuals should be used only as a last resort and must be justified as the least restrictive alternative. I'm looking forward to a lively discussion. With that, I will hand it over to Professor Christo. Thank you.
Thank you, Lindsay, for that introduction and on the very important topic that we're handling today. And thank you to Paul for organizing this distinguished panel of experts on the subject, very timely and very important topic. I'm here today to talk about, and by the way, greetings to the audience here for the AALS conference. I'm here to talk about the right to travel during emergencies such as COVID, and particularly stay-at-home orders and their constitutionality. I'm going to do this in three parts, and I'm going to do it relatively quickly so we can allow for time for Q&A. First part is I'm going to talk briefly about the right to travel and the constitutionality. And I'm going to take us back to law school and tell us that we were probably misled in law school as to our right to travel. Point number two, I'm going to talk about the stay-at-home orders, particularly the one in Louisiana, my home state. I'm at Loyola University in New Orleans, and I'm going to analyze and discuss the Louisiana stay-at-home order and the constitutionality of it. And thirdly, I'm going to talk about the dangers of emergencies as they relate to civil liberties. And I'm going to reflect particularly on some of my studies of the Hurricane Katrina emergency and civil liberties that were abused by the government during Hurricane Katrina. I think I'm going to start, quite frankly, with the horror, not so much of Hurricane Katrina, but a hypothetical potential abuse of what could happen and what could have happened during COVID. Not so much with Louisiana stay at home, but this is a hypothetical for you to consider. What if a president calling the COVID pandemic a war, which our president did refer to as a war, used the war powers that is granted by the Constitution to order federal troops, and I think he did that as well in relationship to protest, into highly democratic inner city communities and forced a quarantine in those communities for 2 weeks prior to and leading up to the presidential election. Well, I think that would be a horror. Fortunately, it did not happen. Had it happened, there's nothing that would stop the president from doing it. It would be subject to a Supreme Court review as to whether or not he had the authority to do it, but the damage would already been done. And as a result, the president might continue to be the president-elect, and we might not have a new president coming into office. And I'm not trying to make a political statement. I'm just trying to point out that the right to travel is so critical to liberty. It is so critical to all of our constitutional rights. And we like to believe that we have a constitutional right to travel, but I'm going to challenge our understanding of the right to travel next. So the question is, do we have a constitutional right to travel? So to go back to law school, and of course we all believe and we're told that there is a constitutional and fundamental right to travel. But unfortunately, that was a misstatement. Why is that a misstatement? Well, I think the reality is, and my studies have shown, and if you want to research it, you can research it yourself, there is a right to interstate travel protected by the Constitution. There is no, unfortunately, constitutional right, Supreme Court decision, or otherwise, to provide for the right to travel within your own state, known as intrastate travel. And I'm going to express some evidence of this in a minute. There are jurisdictions, courts of appeal decisions in half of the circuits that, quote unquote, guarantee a right to intrastate travel within your own state. But there's equally a number, particularly within the southern part of the country, of circuit courts, including the Fifth Circuit Court of Appeals, that has expressly stated that there is no constitutional or fundamental right to travel within your own state. Let me just say it one more time for emphasis. At least in the Fifth Circuit and other circuits, particularly in the southern part of the country, there is express decisions by the courts of appeal, federal courts of appeal, that say there are no constitutional or fundamental right to travel within your own state. Now, I don't like that. I'm not happy about it. I would wish we had a federally protected constitutional right to travel that's been stated by the U.S. Supreme Court or even by the Congress, but that has not happened so far. Why do I know this? I know this because of my study of the Fifth Circuit's decision relative to Hurricane Katrina cases. And let me talk to you about those cases for a minute. So in New Orleans in 2005, we had an emergency, Hurricane Katrina, and we had federal and state intervention of people's behavior for their protection. One of the things that happened, unfortunately, that was not for their protection. One of the local police departments adjacent to the city of New Orleans decided that they would protect their community by barricading a bridge, which was the only bridge out of the city of New Orleans, which was flooding, into safety. This police department, basically barricaded this bridge, the Crescent City connector, and did not let pedestrians, hundreds of thousands of pedestrians, cross over into safety. Which you would think, my God, how could that happen? These people are basically trying to get out of harm's way. Well, subsequent to that, those affected individuals sued in federal district court judge. There was no constitutional or fundamental right to travel within your own state. And so as a result of those decisions that came out of Hurricane Katrina, within the Fifth Circuit, which is the states of Mississippi, Louisiana, and Texas, today, there's no fundamental right to travel within your own state, intrastate travel, compared to interstate travel. So when the state of Louisiana, governor of the state on March 22nd, 2020, followed along with so many other states, issued a stay-at-home order, a statewide stay-at-home order that had a very low bar, so to speak, relative to the right to travel, i.e. that order could have been very restrictive and probably still been constitutional relative to present law, okay, unfortunately. The good news is that stay-at-home order had lots of holes in it. The biggest hole is if you were involved with essential activities. And the essential activity list was very broad. It included visiting relatives, going to work, going to exercise out in open air. So there was a lot of loopholes to that stay-at-home order. Notwithstanding, that was at the state governor's level. It certainly was possible for local officials to read into that order, and some of them did, to provide greater restrictions to the right to travel. And you say, well, what could those restrictions look like? Again, it's as good as the police department. The police department could have very much said, we're going to quarantine, we're going to section off the city, we're going to avoid allowing people free movement for constitutional purposes, including the right to vote, including the right to have an abortion, including the right to go to church. So I'm going to end with that introduction. I'm going to mention again that there are lots of potential abuses to the stay-at-home orders, and we'll discuss some of those further in our conversation. Thank you.
Great. I think I'm next. Can you hear me? Okay. Lots to talk about and much in the Q&A. So I'm just gonna keep to some very short remarks and to some extent riff a little bit on Lindsay's quite compelling and interesting framing of these issues, in particular her exhortation, right, on behalf of her and other folks who work regularly in the public law and public health field about how we should be thinking about this next. The record of judicial intervention as we sit here in early January, about 10 months in to the pandemic, has been uneven, to make an obvious point. Judicial intervention and judicial review at the state and federal level has been inevitable but problematic. And I say that not only by cherry picking particular decisions that I think are erroneous, but I mean from a wider context. I think the judiciary has not, I'm thinking particularly, but not exclusively of the state judiciary, acquitted themselves extremely well. We talk about, Lindsay and others have talked about the value and the imperative of independent judicial decision-making. But I think if you actually look at some of the blockbuster state cases, Wisconsin, Michigan, even Massachusetts, which came out the other way, I'm not sure that these are models of independent judiciaries in actions. They may reveal all of the predicaments that are associated with a mostly elected judiciary in a highly fraught, polarized political world in which we're in with respect to the pandemic. A couple broad observations without, again, looking at the particular doctrines in any detail. Governmental power has proved remarkably resilient, for better or worse, in the face of this pandemic, which is to say that as a measure of court decisions, whether they've been at the lower court level or the high court that have upheld governmental power, or governmental decisions, judicial decisions that have mostly punted and declined to intervene, the government has won much more often than they've lost. We can say that a lot of that has been particularly at the level of procedure, doctrines that only lawyers and law professors love, like standing and mootness and all of that, or a high level of deference with the courts essentially declining to intervene. By any measure, governmental orders, indeed extraordinary governmental orders of, if not unlimited duration, of long duration, the ebbs and flows of the regulations with respect to the pandemics, has revealed a judiciary, by and large, that has been, with the rather large exception of religious liberty, a deference to court decisions. It's also remarkable, quite frankly, how little judicial intervention there has been on issues that we might have regarded as extraordinarily hot button issues. Mitch mentioned one, which is travel bans. We can probably count on one hand the number of important state court decisions that have looked closely at the constitutionality of travel bans. Now, to be fair, a lot of that is because a lot of the most draconian travel bans ended or were at least postponed as long ago as the summer. But there's been very little big time litigation. Schools. For all of the attention and hand-wringing many of us engage in with respect to schools, opening, closing, and the like, there's been not enormous amount of litigation in that particular area. I'll make one observation about state constitutional law, which at least strikes me as important. I hope the others of you will agree, is that by and large in the state court decisions, state Supreme Courts and others that have looked at the balance between governmental regulation and civil liberties, we haven't seen very much attention paid to the unique quality or characteristics of state constitutional rights vis-a-vis federal constitutional rights. So although we know that state constitutions are filled with so-called positive rights, right to education, right to healthcare, sorta, right to the environment and all of that, I haven't seen very many instances of the state courts invoking unique state constitutional rights, special legislation, public purpose requirements, and the like. Nor have I seen state courts intervene in order to protect economic liberties. which has been more characteristic of state constitutions than federal constitutions. I want to make one general observation. I don't know how you all can judge whether it's controversial or not. The case law and the adjudication over the scope of governmental restrictions, pandemic restrictions, particularly administrative restrictions, I mean those imposed by the governor under his or her emergency powers, those imposed by state administrative agencies, departments of public health and the like, have come at a very inopportune time, in that they have come at a stage in which there's been this, what I will call an unholy alliance between the left and the right against the administrative state and against the use of broad administrative power. So when Justice Gorsuch tries to, or invokes the rather clever phrase, the Constitution has not taken a sabbatical, it's just taken a short break at most, that is a red herring, it seems to me, and it addresses a large question, which is the faith and hope and deference we pay to administrative agency officials making these decisions. So I won't get into the weeds with respect to these particular cases. Some of the key state cases have involved the renaissance, as it were, of the non-delegation doctrine, of particular doctrines involving separation of powers, of the question of the authority to engage in governmental action without formal rulemaking, as in the Wisconsin case. But I just say from 10,000 feet that the sort of the anti-administrative state approach that has been characteristic of particularly more conservative rulings befits, in many respects, the experience that we're having now in federal constitutional law and federal administrative law that has bled over to state administrative law and state constitutional law, which is a grave skepticism about the role of non-elected, in particular governmental officials and governors exercising administrative power in these contexts. So I'll stop there, and I hope we can get into more of this in question and answer. And I should have started out by saying how pleased and privileged I am to be part of this panel with such an august group. So thanks.
All right. Thanks to all of you for being here and to my co-panelists for their insights. I wanted to add just a couple of points to the discussion before we turn to Q&A, and I think actually the 2 points I want to add build nicely on Dan's. So the first thing to mention, just stepping back a bit, is to observe the relevance of political polarization to our discussion today, and politics to our discussion today. Polarization has affected state responses to the pandemic itself, as well as state-level discussions and evaluations of the appropriate scope of emergency powers. But pandemic response is not an obviously or inherently partisan or divisive type of policy action. I say that in part because if we look internationally, including but not limited to New Zealand, where I'm currently living, the response was treated as a pressing community-wide concern, not really a politically divisive one. Partisan divides exist here, but not really over this. But at least in some US states, obviously, partisanship has been a defining feature of policy responses. And there are probably varied reasons for this that you are all plenty familiar with. Political scientists find increasing polarization in state legislatures significantly since 2010. The COVID-19 crisis occurred in an election year. The type of response that other nations used effectively, acting quickly to pay people to stay home, bumps into political flashpoints in the US regarding government support and redistribution. And duration was a problem. Once national leadership failed, as Lindsay mentioned, states were on a very difficult and long road, and it's harder to bring people together around a long and sometimes seemingly hopeless battle than around a quick and likely simple victory. So the crisis accentuated an already pronounced degree of partisanship within state governments. And in states with highly politically fractured ecosystems, that polarization ended up being an important part of the story in how measures were enacted, as well as which were upheld and which were struck down. So this is part of the story in Michigan and Wisconsin, as Dan mentioned. In Michigan, private plaintiffs with the support of the Republican-controlled legislature successfully sued to invalidate the Emergency Powers of Governor Act, and the then Republican majority of the state Supreme Court ruled that it violated the non-delegation doctrine. In Wisconsin, the state legislature itself successfully sued to invalidate the executive branch's Safer at Home order, and in a non-delegation infused ruling, the court held that the public health statute was not broad enough to cover the order, and that the order should have gone, as Dan mentioned, through the state's rulemaking process, over which Republican legislators exert significant influence. And yet, most states have upheld similar measures, or as Dan said, punted on them in a way that left the status quo in place. So my point here is simply to observe, maybe obviously, that politics may well be a better way of understanding the policy actions in the states than any sort of question about either the optimal or scientific public health response or the meaning of relatively open-ended statutory authorizations. And if one steps back thinking about public health objectives and international comparisons, we should not lose sight of how unfortunate that is. Second quick point is, well, what would better look like? So it seems from our discussion that an appealing emergency or pandemic response would afford both democracy and rights protection. In other words, right, we want to, if we're going to calibrate emergency powers over the next decade, as Lindsay said, we want to find some solution that maintains popular support while also not violating civil liberties. And in pursuing those goals, one prominent concern, which my colleagues on this panel have written about and which I have written about in the past, is the possibility that governors, will act essentially unchecked. If governors act without any checks, we might get pandemic response that violates individual liberties. For that matter, we might get a pandemic response that runs against majority preferences. That's a real concern, and it's a familiar one in the emergency powers literature. If governors run afoul of those criteria, then we should indeed be skeptical of their measures and develop a reform agenda accordingly. And the Michigan and Wisconsin cases that we've mentioned certainly speak in that same register of worry about executive overreach, using notions of democracy to strike down executive actions regarding COVID-19 in favor of legislative involvement. The Michigan court underscored that an important basis for the non-delegation doctrine is to ensure that, quote, the people are not unprotected from uncontrolled arbitrary power in the hands of administrative officials. And in Wisconsin, one justice wrote that delegations to administrative agencies, quote, must be carefully circumscribed in order to avoid the people being governed by unelected bureaucrats, because the founders' vision of our constitutional republic was that supreme power is held by the people through their elected representatives. But I think that when it comes to assessing how to reform pandemic responses, these decisions and some of our commentary miss one important consideration, especially in these politically divided states that I'm talking about. And that is that, at least in those states, the counter-majoritarian branch may actually be the legislature. As I point out in a new draft paper called Counter-Majoritarian Legislatures, both Michigan and Wisconsin are states in which one party has repeatedly won a majority of legislative seats despite getting a minority of the votes. In contrast, gubernatorial elections are held by a simple statewide vote, no districts, no electoral college. Governors, despite their faults, are actually usually a pretty good measure of the popular will. I won't bore you with more detail about my paper, I promise, but my intervention in this discussion before we turn to Q&A is simply to say, to the extent that we do want to democratize pandemic response, we should be thinking critically about what institutions can serve that role. We shouldn't reflexively invoke only legislatures as the people's true voice when we think about an appropriate emergency response. So I'll leave it there and look forward to our discussion.
Great. Thanks to our panelists for very interesting remarks. And I'll get things going with a question that I think hits on a theme that ran through most of your presentations. Professor Wiley referred to one of the interests that we're balancing here is the need for a nimble, expertise-driven approach. I think some of the resistance to these emergency orders is at least partly seated in the notion that they're not being driven by expertise, at least in a scientific sense, that they're being driven by value judgments. For instance, that some governors just don't value in-person worship the way some other significant percentages of the population in their states and in this country do. You have all kinds of different ways in which states have declared some businesses essential or not. Personally, I wish the newspaper would put quotes around essential every time they refer to essential businesses, because it is fundamentally, or it is at least partly a values-based decision. And so I wonder, how much of the litigation or the response that we're seeing is based on a skepticism that governors or these other authorities really are using science-based expertise. And then I also wonder how much that plays into what Professor Rodriguez identified as this emerging skepticism about the administrative state. So let me hand that off to Professor Wiley first, and then I'd love to hear others.
I think this really has played a big role in the politics around opposition to executive orders and in the judicial decisions. I think we've seen it play very readily into a kind of pre-existing narrative about, government shouldn't pick winners and losers. And then, of course, we've seen the Supreme Court, in my opinion, really conflate two different aspects of what social distancing decision-making requires at the government level, which are the risk-based classifications, right? An assessment of the extent to which any given setting or type of interaction poses a risk of increasing not just individual transmission, but community transmission, right? Really having a public health impact on the one hand, and on the other hand, the idea that to be successful, social distancing isn't intended to freeze everyone in place for 12 to 18 months. That's just not possible. And so there's an assumption that you're achieving an overall reduction in social networks of somewhere like 40 to 50 or 60%, depending on your goals. And that leaves some amount of social interaction that can continue. That's based on priorities, not based only on risk. It is based on values, priorities other than public health. And as you've pointed out, the orders have often reflected values, choices that align with the lived experience of the people who are designing these orders, who tend to be relatively well off, tend to have the resources to order in, to entertain themselves, to conduct their work remotely, and tend maybe not to view religious worship as an essential component of their kind of day-to-day life, as something that can instead be put on hold. That is inevitable. Public health is inherently political. It is not inherently partisan, as Miriam pointed out, but it always involves balancing scientific evidence about risk against other priorities.
So let me jump in on that. On that last point, I mean, I'd say here. The notion that the rise of sort of progressive era, New Deal era, kind of invocation of expertise, there's no Democratic or Republican way to pave a street, and all of that undergirds this notion that it's mostly about expertise is and always has been much of a red herring. Of course, there's a Democratic or Republican way to pave a street. Of course, progressive era, New Deal era administration involved value judgments. It involved different kinds of value judgments, and it did involve the displacement of partisan politics with more rational decision-making, scientific decision-making. And I'm saying as an ideal, I'm not being naive about whether that always worked that way. But the notion that there are values embedded in scientifically driven choices is not something that is COVID-19 related. It goes back to the heart of the administrative state. But Paul, nonetheless, you put your finger on something important, and so does Lindsay, which is a distrust that emerges from the way in which the lines are drawn, not just the simple fact of lines. And I apologize by bracketing the religious issue as a special case, because that seems evasive, and I suppose it is. But let me actually address at the level that Lindsay's brought this up a couple times, and I certainly agree about the duration issues. So, the public health authorities and those who are meaningfully invested in this know that, kind of turbocharging lockdowns for shorter periods of time, right? Limited duration, really focusing in on the science would be much more efficacious, even though, it involves some sacrifice that requires the kind of supplemental support that she talks about and all of that. So I'm talking, not to be mysterious about it, like a Thanksgiving lockdown and things like that. But the lack of willingness of governors, really red states, blue states, and the others, purple states, to engage in those very draconian but meaningful and public health driven actions leave a lot of folks to say, basically, they've just kicked the can down the road, and the unwillingness to engage in super hardcore lockdowns of very limited duration suggests a distrust about their motivations and their commitment to science. And so I think that reinforces the sense of skepticism that is born of the notion that they are throwing darts against a dartboard. I'm not introducing that fact that piece of evidence for the truth of the matter asserted. I'm just saying that undergirds, I think, a lot of the skepticism from both sides of the aisle.
So we have a question in the chat about shouldn't courts demand evidence that these restrictions make sense? And I think so much of that depends on the format in which courts are potentially reviewing particular restrictions. We're often primed as law professors to think about, federal law first, like equal protection or due process claims. Those are reviewed very deferentially, of course, traditionally at least, under federal jurisprudence. State law usually allows some other avenues, like, for instance, if it's a rule from the Department of Health and it's promulgated through the administrative process, one could challenge that through a state APA, at least make sure it's not arbitrary and capricious, and there'd be the notice and comment process. One thing that almost all governors have done, though, is attempted to get around their normal APA process at the state level. For instance, in Oregon, our governor, Kate Brown, says that the executive orders related to coronavirus restrictions are all exempt from administrative review. So what would a good process look like, if there is one, that would allow the courts to review gubernatorial or other executive orders for evidence that these make sense as a matter of restrictions? And for Professor Crusto, how would that look in the right to travel context?
Thank you, Paul. I think the answer is that in Louisiana, the governor acted not purely as a matter of an executive order, but pursuant to state legislation. There was an enabling legislation that basically says in these public health emergencies, the governor has the authority. We give the governor the authority to do A, B, C, and D. And so I think the answer in part is that we should have legislation at the federal and state level that deals with states of emergency. And I think sometimes we do, and sometimes there's a void. And so at least in Louisiana, I think the stay-at-home order was more, say, constitutionally protected because it was subject to the police power that was enabled by state legislation.
I could just jump in for a second on that. I think actually that Paul mentioned state administrative law. I think that states can actually be quite successful at calibrating an appropriate level of deference based on both who the actor is that issued the decision or order and what types of rights it affects. And I think, as Lindsay and Steve Laddick have written in an essay, I think that sort of judicial review can be part of a fruitful dialogue between courts and the executive branch or other actors regarding sort of, how to ensure that a response is both evidence-based and transparent, right? That reasons are actually given for government action, which is sort of a core principle of administrative law. But I think it's important not to lose sight of the importance of remedy when we're talking about, sort of demanding evidence for various measures, because as far as I know, obviously not a public health expert here, but I don't think there's any science-based sort of case for having absolutely no intervention, right? So if the remedy is to strike down everything or to, completely leave a gap, then that seems arguably as problematic as, sort of a measure that, as Paul suggests, sort of, picks a winner or a loser without a sufficient justification. So it seems like one area in which reform efforts should be targeted is sort of setting a model of judicial review that, that does demand justifications from executive branch actors or others, while also not leaving absolutely nothing in place in the meantime, right? And that's one of the problems I think that some states have faced.
Yeah, and just a reminder for folks in the audience who may or may not have dived into these cases, while we as law professors might tend to focus on separation of powers or non-delegation doctrine, if I'm getting this right, and Miriam could correct me, the Wisconsin case about whether or not the Department of Public Health could issue a stay-at-home order, all depended upon how you interpreted the term rule or order in the state statute. So it was pure statutory construction. And there was a concurrence based on non-delegation doctrine. But so how these statutes are written with precision is really going to matter going forward. And I don't think, many of these legislatures were thinking that carefully when they wrote them 50 years ago, that they might be allowing, sort of gubernatorial rule for 9 months. But who knows?
Well, can I just jump in very quick on that? They may not have been thinking about, infectious diseases, the pandemic and all of that. But Wisconsin, like these, basically every other state, was not writing against a blank slate. They were writing against a slate of federal administrative law that had defined the scope of order quite broadly ever since the APA, if not before that. I mean, Wyman Gordon and, a whole slew of cases. And so administrative agencies acting through general, I'm trying to avoid using the term rule because that's circular, but through sort of general lawmaking through the utilization of orders was well established. So the notion that Wisconsin was discovering some new doctrine of administrative law, I know less about than Miriam does about whether there was something unique about Wisconsin administrative law, although I looked for it hard in 161 pages of that opinion, didn't find it. So the backdrop of federal administrative law made the majority opinion strikes me as all the more peculiar.
So one of the most famous cases in public health law is Jacobson versus Massachusetts, in which the Supreme Court in 1905 upheld Massachusetts and Cambridge's requirement that everyone be vaccinated against smallpox under penalty of, if I remember correctly, $50, something like that. And that's been cited left and right, at least in federal court, when these emergency orders have been challenged. And this is something that Professor Wiley's written about already. How much deference should we read into Jacobson? What do our panelists think the future of Jacobson is? I think we see some skepticism. We saw some skepticism about Jacobson and the deference it's been accorded to, or how it's been cited to accord deference to state officials in Justice Gorsuch's concurrence in the Roman Catholic Diocese case that came out on Thanksgiving Eve, that many of you are familiar with. So what do you think the future of Jacobson is?
So I'll start off as someone who has written about and taught Jacobson extensively for my entire career. It's been really strange to see the Fifth Circuit's interpretation of that, which is not something that predated this pandemic, as a kind of hard line, bright line rule about a suspension standard of review that the Fifth Circuit essentially said if the Supreme Court met for example, abortion precedents to trump Jacobson, it needed to specifically say in those precedents, and this also applies in a public health emergency. It overrides that Jacobson suspension standard, which none of us understood to exist before the N. Ray Abbott decision. What I'm most concerned about is that Jacobson has an enduring meaning that is very different from a suspension standard of review. And the rejection, I think the very clear rejection by the new majority of the Supreme Court of Jacobson as a suspension doctrine, I'm worried that easily could bleed into a more general rejection of Jacobson's more enduring meaning, which is that public health needs or common needs for security and protection in other contexts as well can readily outweigh individual rights when the justification is there, that those exigencies are taken into account, that, as the court said, the power to decide what must be done in an emergency must be lodged somewhere. And there's deference to the legislature's decision to lodge it with a body that's been selected for its expertise. I worry that those meanings could be lost. We could very well see that play out with respect to vaccination requirements. I don't expect compulsory vaccination requirements to hit the courts while we're still under an emergency use authorization for vaccines. But COVID is likely to be with us in some form for many years to come. Whether it's even, just just a seasonally endemic problem like the flu, but still more severe than the flu. And so I think these are issues that are going to continue to have relevance for COVID itself and for public health more broadly. I read Gorsuch to be sort of telegraphing that he sees himself as a potential swing vote on compulsory vaccination. He delved into Jacobson as a vaccination case in some detail. So I think that's going to be an important issue to watch.
100%. What Lindsay said, both as a description of what the court is doing and the fear they had. If I could wave a magic wand, which of course I couldn't, and discourage the court from invoking Jacobson as a bromide rather than as a statement, a very sensible statement of the deference, I would do that. And by the way, although this is off topic, I would also wave that same magic wand and ban the rather overly clever use of korematsu as standing for some proposition about what the court is doing or not doing. That's a separate discussion, but I think that is a red herring on another dimension. But to the question of Jacobson, 100% what Lindsay said, in my opinion.
So we've seen some pushback from state legislatures. Some have proposed to strip governors of their emergency authority, thinking that governors have abused that authority by shutting down businesses. How far have those made it, and what do our panelists think the prognosis is for emergency powers going forward? Do you think we will really see a flowering of reform of these statutes at the state level? I see Lindsay shaking her head yes. So
I'm actively working with legislators at multiple levels of government on these questions. A significant number of bills have already been introduced in state legislatures over the last several months, and we're now going into a January session where I anticipate that we'll see more of that. I think there are going to be phases to this, much as there were in the aftermath of September 11th attacks and anthrax attacks, much as there were in the aftermath of fears about bird flu, and then the failed Katrina response, and the SARS outbreak and Ebola. And the phases will shift as the political winds shift. But right now, what I'm most concerned about is this kind of strong motivation on the part of some, particularly state legislators, to take a tough stand against executive authority by wholly stripping executive power, which we've seen more at the local level successfully. We've seen some local governments convert their county health officers' role to purely advisory. We've seen efforts to impose non-renewable time limits on emergency declarations at the state and local level. I do think reform is necessary, but my personal efforts, and I have a health affairs blog post coming out summarizing a Yale Health Journal article on this, are that we need to offer more moderate proposals as counter proposals to put forward that recognize that the pandemic response was failed, that reforms are necessary, but attempt to preserve our ability and our preparedness for future emergencies. And one of the lines I constantly use with state legislators who are very anti-executive public health authority is, whatever you think of the response in 2020, particularly in the early months of 2020, if you think that was overreach, I can help describe some other kind of threat that you might feel differently about, whether it has a higher case fatality rate or disproportionately threatens young children, as polio did. There are situations where we would all agree there should be executive authority, and it's really important that we not let this backlash against the 2020 response cripple us going forward.
So, Miriam, I'm interested in your thoughts on what a legislative response might look like, since you've talked about how in some states these legislatures are, at least currently, and I don't know if there's any change on the horizon, counter-majoritarian. So what would a majoritarian emergency framework look like? Or in certain states like Wisconsin, Michigan, are we stuck with the fact that anything that comes out of the legislature is necessarily the fruit of the poisonous tree, so to speak, and that the legislature passing it is, counter-majoritarian? Although I guess they have to get the governor to sign on.
Right. That's what I was going to say. So actually, no, the legislative process, as opposed to end runs around the legislative process, tends to be what's sort of what we learn in law school when we learn about bicameralism and presentment. It's the involvement of multiple bodies, and a statute that can get through that process has strong markers of majoritarian pedigree. The problem that I was describing is more, there's a law in place, which was actually passed through those channels. And then because of some of the concerns about executive overreach that Lindsay just described, either the legislature or an ally of the legislature sues to strike down or undermine the actions taken under that existing statute. And so what you effectively have in that case is a minority veto point that leaves nothing in place and that takes no action. And my argument was just that it's not clearly more majoritarian, and in fact, it's clearly not, to have a sort of minoritarian veto ensuring that no action is taken. But no, I think that, it sounds a little bit like fantasy land in some states, but if there could actually be, a productive dialogue and some compromising and a bipartisan legislative package, I think that would be terrific. Obviously, I would defer to Lindsay on the particulars of what should be in it. But if we don't see that process happen, then we end up falling back on these sort of relatively vague, not fully modernized statutory authorizations, and the courts end up then deciding what they mean. And I think that's where we are now. So legislative reform, I think, would be terrific. Legislative reform that reflexively takes away preparedness, though, would be far less so.
Can I just add quickly, and I suspect I'm preaching to the choir here with respect to Lindsay's proposals and others, but I think it also should address the state and local conundrum, right? Which has been, Paul, you know this from your own work. I mean, we have maybe earlier in the pandemic than now, but whether you're talking about masks or other things, some real challenges given the diversity of home rule authority across the states. And so we remember what happened in Georgia and Texas and Arizona, where I am now, and others. And so I hope that the reforms among legislative reforms will be drilling down into the nexus between state authority and local authority and making these judgments and decisions as well.
Yeah, just briefly, while those legislative proposals have typically come from the right, I think that the left and individuals should be very concerned about overreaching. Fortunately, I think we've had a shared values. We didn't really have a lot of real truly overreaching. But imagine legislators or governors who basically use the opportunity to restrict access to abortion or voting rights for minorities and things along those lines. So I think we got lucky. We didn't get totally lucky, but we got lucky that there's a shared value in the government at this time for the most part. But I think we should very much be concerned about individual and minority constitutional rights.
So there's some discussion and a question in the chat about vaccines. Of course, we know we have at least 2 vaccines approved by the FDA that are being rolled out, although in some folks' opinions, quite slowly, at least in certain states. But that, of course, raises this question of how mandatory might these vaccines be? Currently, they've been rolled out as being sort of optional. We hear private entities like hospitals talk about making them mandatory for their staff, although I haven't heard that any have done that yet, but I've heard that is probably coming. We also hear murmurs about including them among the mandatory vaccines for children to enter school, but I haven't seen that yet. And then there's supposedly, I haven't looked at the text, but supposedly a bill in New York State to require vaccination of every person in the state, or every adult at least. So what do our panelists think about what the future holds with respect to how mandatory these vaccines might be? Might that be something that a legislature could pass, or could a governor order that under his or her emergency authority? And how do you think the courts would react?
So I'm going to jump in on the private part. I'm going to be a little evasive on the public authority part, because I think from a political point of view, my prediction is the states are not going to do this. They're not going to impose a state mandatory vaccine. I could be wrong. I know less about New York in that regard, but let's stipulate for the moment that the states won't have the political wherewithal to require it. So this will get given to private authorities. I'm very troubled by the EEOC guidelines, as I understand it, which have basically said that schools shall not require vaccines as a condition for returning, so long as vaccines are under the emergency use authority. So the FDA would have to make it, remove it from the emergency use authority and part of the regular authority, as I understand the EEOC position, in order to enable schools, and I think this is more broadly for private businesses, to basically impose vaccines as a condition for returning to work, returning to school. So that's challenging. So I would, at the very least, recommend a much greater safe harbor, as it were, for private employers and for schools to impose these requirements, conditions. You can call it immunity passports or bio passports, or whatever you want to call it, as a precondition for enabling folks to come. That, I think, is within the scope of private authority, but I think it takes the wherewithal of government through the EOC and others to make that happen.
So I'll just say that those of us who've worked on vaccination law prior to the pandemic, many of us have spoken out for months. I haven't published on this, but lots of friends of mine have, are urging caution about compulsory vaccination in this early stage for multiple reasons, because it can erode trust, because there's not universal access, because the safety profile is not as well understood or well established as it will be under a full license rather than an EUA. There are multiple issues in this space on the public and private side. I'll just highlight a couple. I've been working with the National Governors Association and the National Association of Attorneys General to explore some of these issues. And what I'm hearing is that the kind of first issue to percolate up is going to be private employers, particularly in healthcare, particularly in childcare and education, asking governors to use emergency authority to remove regulatory barriers to compulsory vaccination. The problem there is that one of those barriers may very well be at the federal level in the Food, Drug, and Cosmetic Act. There's at least a prevailing interpretation of that statute that says that when there's an emergency use authorization rather than full license, vaccination can't be made required, potentially even by private entities, that there has to be a right to refuse as a condition of the emergency use authorization. That's not certain, but it's at least a prevailing interpretation that's out there. I think in terms of school mandates, we're only beginning to study these vaccines in older teenagers. I think that could happen, but I think it's likely to be years down the road, not months, and certainly not weeks down the road. It's not going to be for fall 2021. That doesn't mean people aren't asking whether that should be a consideration, but I think that the evidence is very strongly against school mandates, universal mandates for all adults, similar to the mandate that was at issue in Jacobson itself, have been discussed. We don't have any expectation of having enough doses to vaccinate even a majority of the population until, well into 2021, possibly late 2021, possibly 2022. My hope is that by that point, we've exited the pandemic stage. So the higher expectation in my mind is employment-based mandates. Those could be required by state governments, as they are in some instances for flu or for meningitis or hepatitis. But I think the bigger issue in the short run is going to be removal of regulatory barriers, which include employment law barriers, anti-discrimination law barriers, collective bargaining agreements, in addition to the EUA provision itself.
Mitch, what do you see as the implications for the right to travel from vaccines? We've heard about Qantas Airlines saying they're going to require the vaccine. I know Governor Cuomo recently said if you fly into New York from the UK, you need to test. At some point, might governors say you need the vaccine if you fly into a particular state from another country or even from another state?
Yeah, Dan, I think Dan hit on it. When you talk about private actors, I think we're in a different ballgame relative to constitutional issues. I mean, it basically the privilege of travel, as I would call it, on a private airplane would be different from maybe the right to travel on a public bus to go to the grocery store. So I don't really see it as being a significant issue as it relates to airline. I mean, I think it's going to be an issue. Airline cruises. I mean, they're going to be, the cruise ships are going to be, very much inclined to say, look, if you want to get on this cruise ship, as a benefit, you're going to have to basically be vaccinated, before or during. But I don't see it as being as much of a constitutional issue as some of the private, some of the public issues involved.
This might be the final question. Let's see how much time we take. How do you think these last 9 months, 10 months are going to change how we teach both state constitutional law and public health law? So Miriam, from the state constitutional law perspective, what are your thoughts?
Yeah, so I'll bite on this one. I mean, I think that the most important and sort of first order result is just teaching these topics at all. And I think that that's a great thing, right? After 2020, it's impossible to escape, if it was possible before, the significance of state constitutional law, both in the pandemic domain, also in the elections domain, right? All of a sudden, it's become clearer that so much of the lives we live depend on state government. And so I think, hopefully, just a rise in attention to the subject matter will be the first result. And I'm optimistic about that, right? Always looking for 2020 silver linings. I think that that's one of them. In terms of the content, my hope is that there will be more attention to and interest in these types of separation of powers questions at the state level. But I'm not entirely sure that actually the content of what we teach about the separation of powers at the state level has an obvious direction yet, right? I mean, I think there is an interest, as Dan said, in some of these sort of non-delegation and administrative law doctrines, and in the extent to which they are migrating from federal doctrines to state level doctrines, something that state constitutional law scholars often criticize, the sort of unreflexive incorporation of inapplicable precedents. I think there'll be attention to that. But there is a sort of a sense in which state judicial decision-making often has a common law flavor, often a sort of case-by-case, circumstance-by-circumstance approach, rather than really hard-lined, hard-edged categories. And I think that is something we're seeing in the pandemic response. And so rather than saying in 2020, the states moved in the direction of X, more gubernatorial power, I think it might be appropriate to say, sort of, here are a menu of state responses that we saw, types of decisions we saw, and here are all of the factors that we can understand as moving a court toward that decision, both what was going on in the state politically, what was going on in the state in terms of public health, relationships between the branches, processes that were used, underlying laws that were available. All of that, I think, would go into the mix of trying to understand what happened.
So I would just add two things. Absolutely agree with everything that Miriam said. Number one is we're seeing the flourishing, and it's about time of faculty working in their teaching and their scholarship in law and public health. I don't mean that the field emerged as new, but I mean the connections between those like Lindsay and her colleagues who've been working on law and public health for years and years and years, intersecting and interfacing with those of us, myself, for example. I don't know if I ever taught the Jacobson case, I'm embarrassed to admit, in teaching state administrative law or state constitutional law, much less the dynamics of public health. So the connections between those fields will be and ought to be ubiquitous, number one. And number two, without saying anything profound about exactly what it's revealed, how we think about federalism, I think, is going through tectonic changes, monumental changes. And that will bleed into not only how we teach state law, constitutional law, administrative law, but it's about time that it penetrates into how we teach federal constitutional law. And all of us, present company included, pontificate about federalism and notions of federalism, constitutional originalism, and all of that have to really be rethinking not only our priors, but how we engage those questions given what we're experiencing in this pandemic period.
Well, that's a really interesting question, and thanks, Dan, for that insight. I'm a little bit afraid that events like 9/11, Katrina, Black Lives Matter movement seem to come and go without really sinking in institutionally for lots of reasons. I'm hoping that's not the case. Clearly, health equity should be an issue relative to our experience with the coronavirus. But if you remember, after 9/11, there was a robust academic conversation about the nature of an emergency constitution. And that kind of came and went, with the emergency. So I'm hoping maybe that we see courses in emergency law. I hope that there's a lot more syncage, but I think there's so much competition in the academic calendar for what has to be covered for bar purposes. Unfortunately, that doesn't leave as much opportunity. But I would like to see more symposium on these issues, and certainly would welcome all of these speakers to be invited, to Loyola as an example to give a talk on these issues, because they're very vital. And I've been educated. Thank you very much.
So I'll just wrap up by saying right now we are teaching students whose lives have been dramatically disrupted by this pandemic. In a decade, we'll be teaching Gen Z, as they're now calling it, whose early childhood was disrupted by this pandemic, who lost loved ones, who experienced food insecurity, housing insecurity that will have dramatically shaped their experiences as adverse childhood experiences and shaped who they'll become as adults. As someone who's thought about these issues for a while, I welcome the expertise from other fields. I welcome the interest in public health. I would love to see it, as Wendy Parment has argued for many years, much more thoroughly integrated into courses in administrative law, in constitutional law, in tort law, in criminal law. And I think that can only be a positive development. I think our students will expect us to speak to these issues for many years to come.
Well, we are just about out of time. So thank you so much to our great panelists, as well as to our audience. We can't see you, but we knew you were there. And we saw a lot of your comments, so we saw a few of your names. And feel free to contact any of us if you have any more questions. And thanks so much for your attention. Take care, everybody.